now judgment in the matter of Washington PLC and the JS Design Partnership.
I hand down judgment in the appeal in this case. The neutral citation number is 2021 EWCA Civ 1889. For the reasons set out in the judgment, we allow the appeal against the decision of Mrs. Justice O'Farrell, and we allow the claim to proceed.
Appeal in the matter of Mulalley Co Ltd and Martlet Co Ltd.
May it please the Court, I appear on behalf of the appellant together with Mr. Frampton, and Mr. Selby QC appears on behalf of the respondent.
Yes, Mr. Hughes. Now, before we get going, can I just indicate a couple of things? We've read the papers. We have what we hope is a lively appreciation of the issues. If there are any particular bits of the pleading you want to show us, then fine, but you can assume that that sort of detail we have absorbed.
Yes.
And on the logistics, obviously there's the respondent's notice. The point that arises in the respondent's notice logically comes first, in the sense of is it a new claim? You only get into same facts if it is a new claim. But what we thought probably, if this is all right with you, is we would get you to deal with everything. We'd get Mr. Selby to respond, and then you reply, and in the unlikely event you say anything in reply which is new on the respondent's notice, Mr. Selby can reply to that.
Very good.
Yes.
So very briefly, in taking those helpful indications on board, the appellant Mulalley appeals against the order made by the TCC judge, which is Call Bundle page 29, whereby the judge gave Martlet permission to amend its particulars of claim, and of course the court will know that those are behind tab 15. I'll go to them in detail. Call Bundle 144, but the amendments in red, they're about a page and a half, are at Call Bundle 158. Two essential questions arise. On my appeal, whether the terms of the amendment arise out of the same or substantially the same facts and matters as were already in issue on the pleadings, CPR 1742, and then on Martlet's additional ground, whether the amendment was a new claim in the first place. And as my Lord Justice Coulson has pointed out, in a sense those are the wrong way around. It's of course Martlet's additional ground which would logically come first. But dealing with the 2 points, the appellant's essential submission is this. First, agreeing with the TCC judge, we submit that the amendment was plainly a new claim. I will come to that. But if I could just take the court at this stage to the judgment of the TCC judge, so that is at tab 5, Call Bundle, page 31 is where the judgment begins, and if the court would please go to page 43, paragraph 34, and it's halfway through paragraph 34. The essential reasoning of the judge begins here. The essential factual basis of the original design claim in respect of fire safety was that the efficacy of the fire barriers was compromised by air gaps and the use of inadequate fixings. By contrast, the essential factual basis of the proposed amendment is that the use of combustible EPS insulation boards was itself a breach of contract. That, I am satisfied, is a new cause of action. We agree with that, of course. So that's the essentially the additional ground point. But then secondly, disagreeing with the TCC judge, we say on this appeal that the amendment did not meet the same or substantially the same facts and matters test. And if I could show you, again within the judgment, a brief part of the judgment, now paragraph 46, please. Paragraph 46, core bundle, page 46. The paragraph begins, the proposed amended claim is based upon the assertion introduced by the defence. And then third sentence, it is true that the amendment requires the court to consider the additional question of whether a cladding solution that incorporated combustible EPS boards separated by fire barriers was designed in 2005-2008 with reasonable skill and care. Such exercise must of course be carried out without the benefit of hindsight provided by the Grenfell tragedy. Mulalley obviously did not plead that its original design was in breach of contract. Indeed, it specifically pleaded at paragraph 74.2 the manufacturer's advice that the cladding complied with the building regulations in force at the time of the contract. Then equally, the yachtsman in Goode and Martin did not plead that he was in any way negligent in his instruction of Ms. Goode or in executing the jibe. And so I will come on to this question of what the judge called the additional question. We submit on this that the additional question raised by the amendment is a substantial province of inquiry into whether choice and selection of the EPS system as a matter of design was in breach of contract or negligent. That is a substantial and different inquiry from anything foreshadowed either in the particulars of claim or in the defence. In terms of the structure, briefly, of these submissions, 4 stages, and I hope these coincide with what my Lord has indicated would be helpful. First, I propose to take the court to elements of the pleadings. I don't propose to make a meal of it, but I would invite the court's attention to the pleadings, first of all. And the appellant's position is that the issues to be addressed under CPR Part 17.4.2 require a careful analysis of the pleadings and essentially only the pleadings. Second, I will invite the court's attention to some of the decided cases. Again, I propose to do this relatively briefly and highlight some of the passages in the relevant authorities. Third, I have a small number of points on the respondent's skeleton argument. And then finally, I will briefly address the additional ground, namely the respondent's notice. So that's the course I was proposing to take. So in line with that, if I may, I was going to go first of all to the pleadings and taking up, if the court would, the core bundle. First of all, please, tab 14. Tab 14, core bundle 139, the claim form. In very general terms, the claimant claims damages, interest and costs together with such further or other relief as is considered necessary in connection with the defendant's negligence and or breach of a design and build contract dated and so forth. A very general claim form. Over the page at 140, the court will note that the particulars were indicated to follow. The position in relation to that is that the claim form was issued but not served, and then it was eventually served just before the expiry of the 4-month period, together with the particulars of claim.
The judge sets all that out in his judgment. Can we take all that as being accurate?
Absolutely.
Right.
Absolutely. We then come to the particulars of claim, tab 15. I don't propose to take the court to anything other, really, than paragraph 41, core bundle 155.
Yep.
What the court will immediately see at the beginning of paragraph 41 is that there is a reference to design. Mulalley's design of the cladding works, and then there is a portion amended in red, was in breach, and then the court will see 7 lines down, just after the final portion of red, and or Mulalley's workmanship for the cladding works to each of the towers was in breach. A broad plea, we say that broad plea is then understood by reference to the particulars which follow, Core Bundle 156. And again, very briefly, picking up really the headings, if I may. Below particulars of Mulalley's breach of contract, one has the bold italicised fire barrier defect heading. I take that as a signpost. What the court will see from the verbs used in 41.1, 41.2 and 41.3, fixed, left, and then fixed in 41.3. These are workmanship defects. These are criticisms of the manner in which work was carried out. And that goes over the page. 41.3.3, Mulalley used an insufficient number of dowels. And then 41.4, middle of the page, or a little above the middle of the page, as a result of the matters aforesaid, the external walls do not comply. And then briefly, over the page, picking up the heading, insulation defects, top of Core Bundle 158, not properly fixed, that's 41.5. I pass over the amendment for present purposes. I'm going to come back to it briefly later. Over the page, see Core Bundle 160, please. The third of the 3 pleaded particularised defects, substrate defects, and the final 2 lines of that paragraph 42. Mulalley failed adequately or at all to A, repair the underlying substrate, and B, fill in historic penetrations and vents. Just going, if I may, to paragraph 61, Core Bundle 163, as a result of the matters aforesaid, Mulalley has suffered the following loss and damage. We submit that that reference to matters aforesaid must be a reference to the 3 particularised workmanship breaches. But just to deal with a point that is made against me, namely that paragraph 41 is concerned with design also. And if I pick that up now, of relevance, my Lord, my ladies, is the request for further information that we made of this pleading originally. And that's to be found at tab 22 in the Core Bundle. It begins at Core Bundle 376.
Yeah.
Over the page, please, 377. Towards the bottom of the page, under paragraph 41, request in respect of the whole paragraph. The claimant is requested to provide full and proper particulars of the alleged design breaches. Response is at the very foot of that page. The request is not understood. Please see paragraphs 17 to 19 and 23 of the reply. But then these words. Martlet relies on the facts and matters alleged as breaches of Mulalley's design obligations if and insofar that it seeks to contend that its workmanship complied with any particular design. In other words, we say the proper meaning to be given to the references to design in paragraph 41, the beginning of paragraph 41 of the particulars of claim, it is that there are 3 workmanship breaches, if and insofar as Mulalley seek to answer those allegations by reference to a particular drawing or a particular specification having required work to be carried out in that way, then in those circumstances, but only in those circumstances would Martlet say, well, that then is a breach of design? And that, we say, it is the meaning of if and insofar as at the top of 3.7A's. The point that we make at this stage in the analysis is that there is no claim in the original particulars of claim that the choice of EPS insulation system was itself a breach of the building contract. The so-called EPS case formed no part of the particulars of claim. And if I could just make that good by reference to the following 3 points. First of all, the EPS design case is simply not manifest in any of the language in the particulars of claim on a sensible and fair reading of those particulars. Secondly, the context for these original particulars of claim is quite important, and there are two aspects to that. So, context for the particulars of claim. 2 points. First, on the 13th of November 2019, the adjudicator dismissed the respondent Martlet's claim in its entirety. Martlet had pleaded workmanship.
I don't quite understand where this goes. You both refer to the adjudicator. If we're looking at the pleadings, we're looking at the pleadings.
Very good.
I mean, isn't that right? I mean, you both make points about the adjudication decision, and I just wondered where that went in terms of the exercise that we have to perform.
I accept that. I accept that broad observation, my lord. That there's a possibility of a point that is made by reference to Goode and Martin. One of the Court of Appeal authorities that I'll take you to explains Goode and Martin based on the fact that the plaintiff in that case could not and did not know what defence the defendant was going to raise, and that was part and parcel of the...
Because she'd been hit on the head.
Exactly.
She had no memory.
Exactly.
Yeah,
but she couldn't possibly have known what the defence was.
Well, I understand that. But that... Well, shall we see where... I don't want to shut anything out, but at the moment, my instinct is this will be turning on the pleadings rather than what the extremely distinguished adjudicator did or didn't do, or what was or wasn't in play within her adjudication.
Very good.
That's my instinct.
And my lord, recognising that, I'll take the point very, very shortly, which is effectively this. The adjudicator dismissed the entirety of the case, including a form of the EPS case. That was dismissed as part of the adjudication. And what is... The judge took an interest in this, in the sense that he asked of Martlet below why it was that the EPS case was not part of the particulars of claim.
Yes, and there's a paragraph in the judgment, I think, dealing with that.
There is, and the answer was it was a deliberate decision not to pursue the EPS case in the particulars as served with the as served claim form. That was the only point I proposed to make, and I'll move on to the defence, tab 16, if I may, call bundle.
Yeah.
Call bundle 166, the start of the defence, and if I could invite the court's attention first of all to page 172, paragraph 34 of the defence. As to the first part of paragraph 41, dealing with design, Mulalley denies any breach of its design obligations. And we say that the meaning to be given to that plea is that it is dealing with the particulars of claim as I've described them, also in light of the replies to requests for further information that were issued and responded to. Going on, if I may, to paragraph 51.
Just before we go there, could you just help me with paragraph 35(1), further down that page? You plead various things that you say there was no contradiction between the selection and use of flammable or combustible EPS materials for use in the works with, and then you set out various things. You don't refer to the building regulations.
No.
Is that a deliberate omission?
No.
Because you've got all the other sorts of things that one would expect to see, including codes of practice and British standards, but you don't refer to the building regulations, although later on you do, when of course you allege that that they don't comply with the current building regulations. So I just wondered whether that was deliberate.
I'm not aware, bearing in mind I put the pleading together, I'm not aware of a significance of that point.
So you're not aware of any significance in not saying here that it complied with the building regs?
No, but my lord will notice, of course, that in that rather general list there is a reference to statutory requirements, and that we felt encompassed the building regs.
Okay, fine. No, that I mean that may be that may be right, of course. All of that is currently, even as we speak, being looked at across town.
Across town, exactly.
Yeah. Okay. So
it's an obvious point, my lord, but of course
there's nothing magical in that, and anyway, statutory requirements. You say that would cover the building regs.
Yes, indeed.
Yeah.
And of course, it's an obvious point, but I suspect I just ought to touch on it. The red is the amendments that are responsive to the amendment that the judge allowed.
I understand that. No, I that's why I asked.
Yes.
By the way, you keep saying red, of course, because this is Her Majesty's Court Service. We have black and white copies, but they are underlined, which these days is going it a bit. Most people do amendments and they just redo the documents, and you don't know what the amendments are. So at least they're underlined. But instead of saying red, you could say in the underlined passages.
Very good, my lord, and I will do so. Thank you.
Okay, sorry, you were taking us on to...
I was taking you on to 51, paragraph 51, because it's at 51 and following. These are the paragraphs that when we come to the amendments...
The paragraphs that they say their amendments are responsive to.
Indeed, and they effectively say, in light of a series of paragraphs from my defence, they then have the amended plea. And the paragraphs that they roll up within that plea begin essentially at 51.
Yeah.
And what one sees...
I've been to this for that reason. So,
very good, my lord. Well,
so 51, yeah.
I don't propose to spend very long on this. It's essentially, from 51 onwards, a chronology of what happened according to Mulalley, but where one lands up in my submission, it is at 84. It's a long chronology. 84, Core Bundle 197, forgive me.
Yeah.
On the 11th of December 2017, DCLG issued the first version of AN14, the Advice Note 14, which was titled Advice on External Wall Systems that Do Not Incorporate Aluminium Composite Material, ACM, as is often referred to. And then we summarise what we say is the advice within AN14 in subparagraphs 1, 2 and 3. And then over the page, causation is a heading above paragraph 90, so Core Bundle 198. It is denied that the breaches alleged by Martlet against Mulalley were a sufficient or any cause in fact or in law of Martlet's alleged loss and damage. Accordingly, Martlet's claim must fail. The considerations which in fact drove the decision to install a waking watch and remove and replace the cladding arose as a consequence of Martlet's duties as the building owner and the application of AN 14. We then have paragraph 91, which is a plea as to Martlet's duties, or some of them, and then paragraph 92. The considerations described in paragraphs 91.1 to 91.4 would have arisen and would have produced the same outcome and consequences as in paragraphs 90.1 and 90.2, absent any alleged breaches on the part of Mulalley. The impact inter alia of the RRO, taken together with Advice Note 14, was that Martlet was required, alternatively Martlet considered that it was required, to undertake removal and replacement of the cladding works independently of the matters which are the subject of complaint against Mulalley in these proceedings. In other words, the whole so-called causation defence is no more than this. The whole of the cladding had to be replaced due to a response to Advice Note 14, which in its turn was a regulatory response to the tragic events at Grenfell Tower. That is, we say, the causation defence. It's pretty much the same causation defence as was advanced before the adjudicator, and no more than that.
But part of that is it makes various points about the composition of the cladding, and in particular the flammable EPS.
It does.
So for example, it's pleaded at 66, that which is page 192.
Yeah.
Martlet knew that the EPS used in the cladding works did not comply with building regulations current as at that date.
Correct. Yes.
So it's and there's a reference further up the page to the building regulations 2007, and in the previous page current in 2017. So what is wrong with flammable EPS is all part of this story.
Well, we say yes, my lord, it is, but as a matter of a simple narrative leading to such matters as Advice Note 14. What is not part of the defence is any detailed discussion of how, for example, Mulalley were not responsible for design. EPS case is not dealt with at all. All that we say in this chronology is the impetus and the cause of the need for the repair and replacement at the towers was driven by matters which are simply not pleaded and advanced by the claimant. My lord, I'm going to move on, if I may, to the reply.
Yeah.
Obviously, the paragraphs of the reply were struck out, 80 to 83.
Yeah, because it was originally pleaded as part of the reply, and the judge said, you can't do that, you've got to amend.
Exactly.
Yeah.
And perhaps I just ought to look at that briefly, if I may. I'm going to go straight in tab 17 to Core Bundle 255, which deals with, identifies the matters which were struck out pursuant to the judge's order. They begin alternative case in bold towards the bottom of 255, and then paragraph 80 struck through. Further and alternatively, even on Mulalley's case on causation, the loss and damage which Martlet claims in these proceedings was caused by Mulalley's further breaches of the contract set out below. And then 81 and following. I don't propose to go to the struck out reply any more than that, save to show that even at this stage, the references to alternative case, the reference to further breaches, and then the reference in paragraph 83 on 257 to causation of loss and damage. This is a completely, well, at this stage in the reply, what Martlet were focused on is a completely independent route, different breaches. Of course, in a trivial sense, the same monetary loss, because Martlet are seeking to claim the whole cost of the repairs and the waking watch and so forth. But of course, it's the same money by a completely different route. And so we say these are the first signs of different breaches and a different route to loss. Now, my lord, my lady, I'm proposing now, please, to go back to the amendment. Tab 15. Core bundle 158. Um, 41.6, a substantial and lengthy amendment, first of all. A couple of points that we invite the court's attention. 41.6 begins if, as Mulalley contends. This is a contingent plea. It cannot, on this basis alone, be already within the particulars of claim, and it must be a new claim. Now, I know that's the province of the respondent's notice in the additional ground.
Well, don't be worried about that. It all links up, and so you know, if you have a point to make, it doesn't matter under which head, make it. So you say it's a contingent claim because it's if that must be a new claim.
Yes, essentially. But if we could then go, please, to the core of this amendment, third line, Mulalley's selection and use of EPS as insulation in the design and construction of the cladding works to each of the towers is then characterised as a breach. That is a new subject. A completely new subject, and just pausing there, selection and use of the EPS, that will, and if the amendment is permitted, certainly will lead to a significant factual and expert inquiry prior to the date of the building contract. Quite different.
Well, there's no dispute that EPS was used. There's no inquiry. Well, EPS was used.
Yes,
this comes down to whether or not the fact that they now have a claim, and you say that's a new claim, and one sees the force of that, whether or not the new claim that says there's EPS insulation, and that was a breach of, whether it's the building regs or whatever it was at the time of the building being built, whether or not whether that arises out of the same or similar the same or substantially the same facts and matters.
Yes.
I mean that's the issue, isn't it? I understand the point that it's a new claim, but there's no dispute that EPS is in there. There's no dispute that EPS is a bad thing. The issue is, and what may be the in inverted commas new issue, is whether EPS being there and EPS being a bad thing was or should have been seen as being a bad thing at the time.
Indeed.
I mean, that's the point.
What's the significant inquiry? You said there's a significant
the significant inquiry, my lord, it is whether at the time of the building contract, the point at which the selection of EPS was made, at that point, was that in breach of contract or negligent? And we say, of course, it will be a significant inquiry because the tragedy at Grenfell has, of course, transformed the landscape in these things. But the building contract was let many, many years before Grenfell. And so there was no Grenfell at the time of the building contract being executed. There was no advice note 14. And so there will be a substantial inquiry before the TCC as to whether the selection and use of EPS as insulation at the time when the contract was entered into was a breach of contract or breach of duty. And that inquiry, I call it substantial, it is simply not an inquiry that would need to be embarked upon either based on the original particulars or based on the pleas in the defence. Neither pleading require that inquiry. Neither of them require it at all. If I could go on to just look at the particularised breaches within 41.6, there are the generic breaches, and I accept that in the first 10 lines of this amendment there are references to contract documents which are already referred to in general terms in the original particulars claim. I of course accept that. But here, within 41.6, they are used for a different purpose to demonstrate breaches of the, well, to support the EPS case. But if I could invite the court's attention to the words after this meant that, 41.6.1, the external walls of those buildings did not adequately resist the spread of fire over the walls and from one building to another, having regard to the height, use and position of those buildings, contrary to Regulation 4 and Requirement B41 of the building regulations. That is an allegation of breach, which will be itself its own inquiry, not an inquiry which was within the purview of the original particulars of claim, not an inquiry that would need to be embarked upon having regard to the defence. It's a new inquiry. It's a new breach and a new inquiry. 41.6.2, the building fabric elements and or components did not provide for a minimum useful life of 70 years. Now, of course, it's right, my lords, my lady, that at paragraph 26 of the particulars of claim, Core Bundle 151, there is a reference to paragraph GDI 010. The paragraph 26 of the particulars, paragraph GDI 010 provided, designs are to provide for a minimum useful life of the building fabric elements and components of 70 years. I accept that. However, going back to forwards to Seat Core Bundle 159, 41.6.2, that allegation is it's a new allegation of a specific kind directed at supporting the EPS case, forming no part of the original particulars of claim, and I repeat the point, no part of the inquiry at trial that would be required to deal with the defence, or any part of the defence. 41.6.3, the stow system that was installed was not suitable for tall constructions. 41.6.4, the stow system that was installed would not achieve a Class 0 fire rating in respect of those areas of the towers above 18 metres. Again, point 3 and point 4 there are new allegations of breach, which all underpin the EPS case, which is the amendment. None of, in my submission, respectfully, those individual points below this meant that, point 1, point 2, point 3, or point 4, none of those matters are matters that would need to be gone into and considered as breaches on the pleadings which existed prior to the amendment. So first, we say the amendment is not within the existing particulars of claim, clearly not. 2, not within the defence. Thirdly, allegations in relation to the selection and use of EPS as insulation as particularised in 41.6.12 and 3 and 4. It is a totally new inquiry. My lords, my lady, I propose now, if I may, to go to some of the decided cases. I don't propose to spend very long in the decided cases, but if I may go there now, unless the court had any questions of submissions so far. Turning to the bundle of authorities, I propose first of all to go to Co-op and Burse. Authorities bundle tab 5, please. As the court will have seen or read,
just give me a minute, sorry.
Forgive me.
No, it's all right. The file has sprung open. Yeah, tab 5.
Yes, please.
Yeah.
Co-op and Burse, bundle, page 39. Co-op had pleaded breaches in respect of warehouse slab leading to specific cracks, but then sought to introduce an amendment to plead that the whole slab was weakened by inadequate steel fibre content. The steel fibre content within the concrete was said to be too low, leading to the risk of cracking in the future. The judge below applied the same or substantially same facts test in favour of Co-op.
Is that right?
Forgive me.
I didn't think he did. I thought that he said it wasn't a new claim.
Correct.
And the Court of Appeal said, yes, it is.
Yes. And they upheld it.
On the same facts and matters point, the judge said it didn't arise from the same facts and matters, and they upheld him. And actually, there's no analysis, I think, in the judgment on that point.
That's right.
They just say, I agree, which is fair enough. If you agree with the judge, you're not going to be wasting time analysing it. But so actually, the key stuff, which you rely on, I'm sure, on the new claim point, is the 23 to 27.
Exactly.
And that's all about new claim.
Bundle page 46.
Yeah.
If we could go to that first of all. And there's a heading, italicized heading above paragraph 19 of the law.
Yeah.
Reference there to Lord Justice Diplock in Latang and Cooper, paragraphs 20 and 21 in relation to what constitutes a cause of action. And then, my lords, my lady, if we could go please to paragraph 23 of the judgment. A new cause of action, bottom of page 46 of the bundle, discussion. In my judgment, it's very clear on which side of the line the present case falls. As Sinclair for Burse succinctly submitted, the original allegation here was of a group of relatively disparate defects in the floors capable of disparate replacement and repair. There's no existing case of structural inadequacy in the entirety of the concrete floors in the two warehouses. What is now alleged is that the concrete of which the floors are constructed suffers from a systemic defect which must result in its entire condemnation and replacement because of its inability to withstand the design load to which it has never yet been subjected. The allegation by way of re-amendment is, in my judgment, an allegation of entirely new and different cause of action. It relies upon a particular and specific facet of the contractual duty owed, of which no breach was hitherto asserted, is the design capability to withstand a pallet racking leg load of 70 kilonewtons. At 24, then, paragraph 24 of the judgment, the judge below directed himself by reference to the appropriate principles, but in my view, failed properly to apply them when it came to the point of decision. Thus, at paragraph 43, he asked himself, what is the existing claim about? A question which, in my view, fails to focus upon the relevant inquiry, which is as to the essential features of the factual basis relied on. And then there is a reference to Lord Justice Millett's dicta in paragraph on finance, followed by the reference to Lord Justice Robert Walker in Smith and Henniker Major. Paragraph 25, however, it was at paragraph 46 of his judgment that the judge, I consider, fell into clear error. He there said, "It is clear that this development, like those under construction in Steamship Mutual, WDA and Aldi cases, is a substantial and complex structure or series of structures. My view is that since the existing claim is advancing a claim for damages for breach of contract in relation to design, workmanship and non-compliance with the employer's requirements, which is limited to 3 specific elements of that development, one being the internal warehouse concrete slab floor slabs, then it follows that further allegations of further defects in those slabs, even though they involve separate and distinct allegations of breach and allegations of loss, are nonetheless part of the same cause of action." And then paragraph 26, Lord Justice Tomlinson's judgment, "I cannot agree with the judge that an allegation of a further defect in the slabs arising out of design, workmanship or failure to comply with the contractual requirements must necessarily be an assertion of the same cause of action as that upon which reliance has already been placed, simply because breaches in relation to design, workmanship and failure to comply with contractual requirements are already in play." Then on same or substantially same fact and matters, paragraph 28, and my lord is right that this is dealt with more shortly by the Court of Appeal. The point...
So this arose, in fact, is this right? This arose on the cross appeal?
Yeah.
Yeah.
The point I wanted to draw attention to in
Sorry.
paragraph 28, if I may, it is towards the bottom of bundle page 47. As Lord Justice Hobhouse observed in Lloyds Bank and Rogers, speech marks, the policy of the section is that if factual issues are in any event going to be litigated between the parties should be able to rely upon any cause of action which substantially arises from those facts. What the Lord Justice Tomlinson then identified in paragraph 29 by reference to the judgment and ultimately agreeing with the judge, it is towards the middle of the page. "In particular, I accept their submissions that if the steel fibre content claim was allowed to be added, that would involve a major investigation into," and then subparagraphs 1, original design of the floor slabs in terms of thickness and steel fibre content, and 2, the extent to which the floor slabs have been constructed using steel fibres with a content below 30 kilograms per cubic metre. Mr. Hughes QC submitted that this would inevitably have been raised at trial, because now it is known that it is a factor which the experts would undoubtedly have wished to raise in order to support or criticise, as the case may be, the remedial work solution adopted by the claimant. However, I do not accept that submission. Briefly, if I may, could I invite the court to look at a further decision of this court, Ballinger and Mercer, tab 7. Bundle page 71.
Other than this was to do with payments into pension schemes, the facts, I've looked at some of the side-barred passages, but I'm afraid if anything turns on the facts, then...
Well, I only to this extent, my lord, I think. The particulars of the claim alleged negligence in relation to a series of actuarial valuation reports. The pleaded reports were 1996, 1999 and 2001. A raft of contested amendments included the claimant seeking to add allegations of negligence in relation to some further reports from 2002.
Okay.
I believe that's all that's needed to pick up at paragraph 33 of the judgment.
Yes.
Bundle page 84, same or substantially same facts. Although he did not refer to authority, the judge correctly formulated the relevant question in this matter in light of the decision of this court in Goode and Martin. That question derives from section 35(5) of the Limitation Act, the language of which, as pointed out in that case, is not accurately or faithfully reproduced in CPR 17.4. I propose to pass over paragraph 34, but then go, please, if we may, to paragraph 35, halfway down the page.
Yeah.
In the Welsh Development Agency case, Lord Justice Glidewell said in an often quoted passage that whether or not a new cause of action arises out of substantially the same facts as those already pleaded is substantially a matter of impression. Paragraph 36, less well known perhaps, is the cautionary note added by Lord Justice Millett in Paragon Finance, where he said, after citing the passage from Lord Justice Glidewell, to which I have just referred, speech marks, in borderline cases this may be so, in others it must be a question of analysis. Paragraph 37, I would also point out, as did Lord Justice Briggs, in the course of argument, that the same or substantially the same is not synonymous with similar. The word similar is often used in this context, but it should not be regarded as anything more than a convenient shorthand. It may serve to divert attention from the appropriate inquiry. Paragraph 38, following the acknowledgement in the first sentence, Lord Justice Tomlinson said this: whilst I would accept the judge did not misdirect himself, he did not, in my view, carry out a sufficient analysis of the extent to which the defendants would be required by the new claims to embark upon an investigation of facts which they would not previously have been concerned to investigate. Paragraph 39 references the 2002 valuations not mentioned in the original particulars of claim, or in the defence, or in the reply. And then, if I could briefly look at paragraph 42 of the judgment over the page.
Well, that's the result, as it were, on that.
Yes, indeed, my lord.
On that, and that's referring to the Welsh Development Agency, which was the one that dealt with the procedure that you adopted and whether something was reasonably arguable, whether the limitation defence was reasonably arguable.
The point that I'm seeking to rely on by reference to paragraph 42 is that Lord Justice Tomlinson in Ballinger considered that the judge below had been led astray to a degree, but by seeing an analogy with the Welsh Development Agency case.
I see.
And so it is
an analogy on the facts.
Indeed.
Because that was to do with,
building,
as he says, further units being constructed. But Lord Justice Tomlinson is saying that this is different because this is 2002 valuations.
Yes, and so I pick it up, my lord, at the sentence, the analogy is, however, unsound.
Yeah.
All 12 units, that's in the Welsh Development Agency case, had been constructed at essentially the same time between October 1980 and November 1981, and in reliance on the same advice from the defendant structural engineers that the floor slabs of the buildings, as opposed to other parts of the structure, did not require piled foundations. The 2002 valuations were, obviously, produced at a different time than earlier valuations, in different conditions, in different form, and on the basis of different data and different assumptions. And then the conclusion and the balance of that paragraph. My learned friend, on behalf of Martlet, but both before the judge and in this court, characterises the EPS case as being part and parcel of an overall product. We say that on applying the reasoning in Burse, applying the reasoning in Ballinger, it is not good enough. It is, my learned friend's case with respect proceeds at far too high a level of abstraction. As a matter of analysis, the appellant contends here that the EPS case is both a new case and simply does not arise out of same or substantially same facts and matters as were already in issue on the pleadings.
Well, effectively, you've got 2 points, haven't you? One, you say on the originally pleaded case, when one's looking at the question of causation, the court would be concerned with an inquiry as to whether or not at the time that the loss was claimed, the complainant would have had to have taken the cladding out and done the works anyway, because at that point in time, the cladding was not fit for purpose based on the knowledge that they had at that stage. Whereas on the new case, you say the inquiry goes back to the point at which it's put in the first place, and you're looking at the state of knowledge of the affairs at that point in time, which is not something you'd be concerned with on the original pleadings. That's the main point you're making.
Absolutely, my lady. And it's not the case that we might, for example, dip into that earlier period at trial on my learned friend's original pleaded case. It would simply not be relevant at all. The reasoning, the thinking, the research that went into the selection of the EPS insulation simply doesn't arise on paragraph 41 as originally pleaded. And it also, critically, does not arise on my client's defence. Simply doesn't arise at all.
Well, save to the extent that your defence presupposes that whatever was put in there in the first place was not fit for purpose, because if it had been fit for purpose, it wouldn't have to come out later.
Well, but my lady, what we say about that is that is going to be at trial an agreed state of affairs. It was taken out, good, bad or indifferent, the reasons for that. There was the advice note, which followed the tragedy at Grenfell, and there is no pleaded issue as to whether the advice note is wrong or right. It was followed.
Ah, but there is a pleaded issue as to whether or not it complied with the building regulations. Isn't there? You've made a positive assertion that it didn't. You could have simply pleaded. There was an advice note. There was a conscious decision taken to follow the advice note. And whether the advice note was right or wrong is neither here nor there. But you didn't do that. You've gone further.
Yes, but well, my lady, what we say about that is that we have not gone so far as to put in issue essentially any of the core facts that my learned friend has now pleaded by way of amendment, which would be necessary for him to succeed on that amendment. It is a...
But what it comes to is, you say it's in breach of the building regulations 2017, and he says, well, if it's in breach of the building regulations 2017, it's in breach of the building regulations 2000. And that is the issue, is that same or substantially the same facts and matters.
Yeah.
Leave aside the new claim, assume you're right about that for this purpose. That's the point.
And my lord, what we say about that, and I accept that, the province and the landscape in which one considers the position in 2017 is altogether different from the landscape province, as I put it, that one considers these matters in 2010, and so it is.
But that may be a criticism of the building regulations. But the question is, with the overriding objective, is that a breach? Sorry, is that something that falls the wrong side of the line for the purposes of this test? I mean, if we cut to the chase, it ought to be possible, and it certainly was possible under the building regulations that I used to plead as a junior. You could say something that is in accordance with the building regulations, and that isn't. And it was as simple as looking at one page. I appreciate that over various governments and years, that has changed. Yeah. And it is now messier to say whether something is in breach of the building regulations. But it still comes to the same point. And that, I think, is the point. That's the core point of this appeal. does the fact that they say, well, if that's your case, then we say it's always been in breach of the building regulations, does that arise out of the same or similar facts and matters? Same
Yes.
or substantially the same facts and matters? That, I think, is the point.
Yes, well, and I accept that.
Yeah.
And what we say in relation to that point is that the factual inquiry is temporally different, necessarily. It is qualitatively different because one is looking at the position of the design and build contractor in 2010 or earlier, considering these matters without all that has happened since.
Well, I can understand that, Mr. Hughes, if the allegation was slightly different from the one that my lord has put, which is, was it negligent to put this stuff into the building in the first place? Because it could well be said, it's been discovered subsequently that this stuff is absolutely awful and it spreads fire, etc., etc. And then you go into the question of the knowledge of the state of the art at the time that it was put in, and all the sort of cladding cases that I was involved in at the bar. But if it was in breach of the regulations, it was in breach of the regulations. And therefore your knowledge as to whether or not it was in breach of the regulations is a bit of a sideshow, isn't it? If it was in breach, it was in breach throughout, and therefore there was a design defect.
My lady, we simply say that there is a difference as acknowledged by the TCC judge in looking at these matters through the lens of 2010, because what was regarded as a breach of the building regulations at different points in time has dramatically changed. The understanding of what is a breach of relevant building regulations has naturally and understandably transformed between 2010 and 2017, so that the inquiry, as I have submitted already, the inquiry is substantially different, both in time and in quality. My lady has that point. I was proposing, in the interest of time, to invite the court to look briefly at.
No, we'll look at whatever. But I think that my lady's questions, and doubtless my unhelpful interjection, I think that's the heart of the same or substantially the same facts and matters point for us to decide.
Indeed, my lord.
Yeah. All right. So we've looked at. We're in Ballinger. Is there anything else?
I invite the court to look in tab 9 at Ackers and Samba Financial Group, please.
Yeah.
Again, I don't propose to go into the fact in any detail at all. The claimant claimed that certain transfers to the defendant of shares in certain Saudi banks was void. The claimant applied to amend their particulars of claim, and paragraph 9 sets out some of the context. This is part of the judgment of Lord Justice McComb. Paragraph 9, application for permission to re-amend the particulars of the claim, the new claims, towards the bottom of the page. The respondents made that application. They deleted entirely the claim under section 127, which the Supreme Court had held was bound to fail, and in its place formulated a claim in constructive trust against Samba personally, a claim which, as I have mentioned, they had previously deliberately eschewed. The new claim is presented, 6.5 pages of pleading, etc. I wanted then, please, to go to paragraph 17 of the judgment. Paragraph 17, towards the bottom of page 114 in the bundle of authorities, the judge held that he was not confined to looking at the pleadings alone to see whether the new claim arose out of the same or substantially the same facts as the old claim. He said he could look at a number of statements made by Samba or its advocates in earlier parts of the proceedings. If we could then please go to paragraph 39. In fact, paragraph 38, please. This is bundle of authorities 118. Goode and Martin was a very unusual case, and then the facts of Goode and Martin are summarised there by the Lord Justice. Paragraph 39, further detail in relation to the procedural history of Goode and Martin. But if I could then invite the court to turn over, there's a long passage from the judgment of Lord Justice Tomlinson in Ballinger, to which I've already taken the court. That quote ends at paragraph 38. I acknowledge straight away, I've taken the court to that. But below that, in my judgment, the last paragraph just quoted is of particular relevance in the present case. With reference to Mr. Onslow's submission, the judge here did not carry out the type of evaluative exercise of the new pleading, which the rule of the decided cases envisage. If I could then briefly go to the discussion at paragraph 44, bundle page 121. It begins in my judgment, the statement by Lord Sumption. If I could then invite the court to look at the next sentence. The new claim is based on allegations of knowledge to be inferred from a multitude of facts said to have been known, or a plethora of sources of inquiry that is said ought to have been undertaken over a very lengthy period indeed. Paragraph 46 towards the bottom of the page. Until the new claim was advanced, the parties were immersed in a complex legal battle about issues of proper law, jurisdiction, and foreign convenience, so much that the ultimately decided issue as to the proper application of Section 127 of the 1986 Act had escaped their attention. Next sentence. It is not surprising that Samba had asserted its good faith, but in my judgment, it's fanciful to assume that the detailed facts now alleged would have been investigated by Samba to the extent that the respondents contend. And then over the page, if I may, paragraph 49. In my judgment, with respect to the learned judge's careful judgment, he did not conduct any real evaluation of the new claim against the facts in issue in the old claim. And then moving, if I may, to paragraph 50.
You somewhat skated over what Lord Justice Sales said in MasterCard, which is quoted further back on page 120 of the report,
Yes.
towards the end of paragraph 41. Seems to me to have some relevance to the current case, because what Lord Justice Sales said is quoted from paragraph 42 of his judgment in MasterCard. In effect, the claimant was allowed to say, well, if you're going to defend yourself against my existing claim by reference to those facts you've now pleaded in your defence, I rely on those very facts if established at trial to say that you're liable to me. Now, translate that to the current case. Claimant says, well, if you're going to rely on the fact that the cladding doesn't comply with the building regulations, I'm going to say it never did, and therefore I can, and that's your fault. And why isn't that a direct analogy?
We say that's not a direct analogy at all, because the amendment that is pleaded hangs off a series of particularised allegations of breach, which were not made previously, don't arise out of the defence. The defence simply pleads a collection of events in chronological order. The substance of paragraph 41.6 and the subparagraphs 1 to 4 that I've taken the court to are a completely new inquiry, which is not, as Goode and Martin, simply turning around the facts in the defence and saying, that is enough, we need do no more, that is our case against you. In my submission, my lady, that there is a significant difference when one analyses the detail of what my learned friend has pleaded in 41.6.
Yeah, sorry, I interrupted you. You were in the middle of paragraph 49.
I was identifying in the first sentence, the references to the judge's careful judgment did not conduct any real evaluation of the new claim against the facts in issue in the old claim. And then paragraph 50, I wanted to draw attention to the content of the second sentence. broadly similar allegations, implicitly made or understood, will not do. Real terms, paraphrasing the words of Miss Justice Coleman in BP and Aon, I find that the new case puts Samba in a position of being obliged to investigate facts and obtain evidence well beyond the ambit of the facts that it could reasonably be assumed to have investigated for the purposes of defending the amended claim at the stage it had reached before the amendment application. And we say that that is a that has direct analogies with the present case. Martlet had.
You're not relying on this case as setting out any principle. You're just saying that this is an application of the principle, and you fall the same side of the line.
Yes, yes, and the analogy that we respectfully draw is that in pleading to the original particulars of claim and in putting together the defence, my clients could not reasonably have anticipated that there would be an EPS case that they would face. And so we say that Goode and Martin does not assist Mulalley Friend, and the amendment in 41.6 invites the parties and invites the court into a factual inquiry, which is way beyond simply a question in relation to the building regulations, or an inquiry simply in respect of the four corners of my defence. It is a substantial inquiry, which, as it turns out, has generated lots of documents and lots of expert evidence for the judge to consider in a few months' time. But in my submission, it is quite different from simply being a case about building regulations in 2017, building regulations in 2010.
Just for the purposes of my note, when's the trial fixed?
March, my lord. I think middle of March. Middle until the end of March. An 8-day trial in the TCC.
Well, I don't usually, as you know, promise dates for handing down judgment, but I think I can safely assure the parties you'll have the judgment before your trial, which might be of use.
Yes, certainly use.
Assuming no variance. No
Yes.
fresh new variance.
No aggressive.
No, but the TCC will then carry on remotely, and nothing gets in the way of a TCC.
I was thinking of my Lord's health.
Oh, I see. Oh.
And my lord's lady, the practical position is that directions and the service of evidence has proceeded on the basis of Mulalley Friend's amendment.
Of course.
So that.
I was just getting getting the time because, I mean, it's as well to say, obviously, we will get you our judgments as soon as we can, but we will be reserving them, and it's inevitable that you won't get the judgments until the new year. Yeah. But armed with that trial date, that might we will do our best.
I'm grateful. Thank you.
Yes, thank you for that. Okay, so that's that one.
Yes.
Any other authorities?
Well, very briefly, I ought to deal with my first ground is Goode and Martin and its application, and I'm mindful of the terms on which the Court of Appeal granted permission, and I don't propose to spend terribly long on Goode and Martin, but if I could briefly draw to the Court's attention the following passages, beginning with Goode and Martin itself, which is tab 4 in the bundle of authorities, beginning at page 25.
Yeah.
Paragraph 20 of the judgment, page 31. Obviously part of the judgment of Lord Justice Brooke. The defendant's solicitors, bottom of the page, now contended that the claimants should not be allowed to make this amendment, notwithstanding that it was founded on the version of the facts which their own client was setting out to prove at the trial. They relied, in this context, on CPR 17.4.1 and 2, and then that is quoted. And to similar effect, if I could invite the Court's attention to paragraph 36. towards the bottom of page 35 in the authorities bundle. It begins, it is commonplace. But then after the citation of Katya and Valuations, all she, that's the claimant, the plaintiff, wants to do is to say that even if the accident happened in the way that the defendant says it happened, he was nevertheless negligent for failing to take appropriate steps as an experienced yacht master to protect her safety as a novice sailor. Over the page, she does not want to rely on any facts which will not flow naturally from the way the defendant sets up the evidential basis of his defence at the trial. Now, of course, my lady, Lady Justice Andrews may well say or think, well, exactly, and the point that my lady makes by reference to the judgment of Lord Justice Sales in MasterCard, it is, of course, made here originally. We say that looking at paragraph 41.6 and the four particularised breaches that are relied on, that is qualitatively a significant move away from what is set out in the defence. That this is not simply a case of what we would say with respect, well, if you were in breach in 2017, you were in breach in 2010, that there is a particularised case to be found in paragraph 41.6 of the amendment, well, in paragraph 41.6, and its subparagraphs, each of them involve allegations which are wholly new and quite different from anything which would need to be gone into where the judge is dealing with my defence.
Well, you're using words like qualitatively different, but the phrase, I think, on which Mr. Selby relies in that sense is flow naturally.
Yeah.
Or maybe Miss Carrot, he's nodding, so I think I've got that
Yes.
right. In what way do you say that this does not flow naturally from the way you set up the evidential basis of your defence?
Yes. Well, and perhaps, my lord, if I could go back to be specific to the amendment.
So it's 41.6.
Yes. So tab 15 in the core bundle, core bundle 158 is the amendment that we're concerned with. And I've taken you.
Sorry, which page?
Core bundle 158.
Yes, it says, yes.
Thank you. So 41.6, the first part is general in nature, and then we have towards the bottom of the page, this meant that, and then we have these specific allegations, 1, 2, 3, and 4, which go over onto 159. We submit that those allegations, which are the gravamen of the complaint, they're the beating heart, as it were, of the EPS case, that they do not flow naturally from any components of my defence. They simply don't. The external 41.6.1, the external walls of those buildings did not adequately resist the spread of fire over the walls and from one building to another, having regard to the height, use and position of those buildings, contrary to Regulation 4 and Requirement B41 of the Building Regulations 2000. That is the first. The minimum life of 70 years is point 2. And I don't propose to dwell on 3 and 4. They're all, for these purposes, the same. That they do not flow from my defence. They use my defence, but then they take matters forward to plead significant breaches, which, and this court may say it's irrelevant, but in my submission it's not entirely irrelevant. My own friend takes these matters forward, having decided in settling the original particulars of claim not to advance this case at all.
Well, why doesn't it flow from your defence? From the evidential, the way you set up the evidential basis of your defence?
My lord, because in my defence, I simply tell a story of what happened, investigation of the buildings, and then the progressive regulatory response to the tragedy at Grenfell. It is simply a narrative in relation to that.
But it's a narrative with a purpose. It's a narrative that has as a purpose to say, well, the reason that you have to take the cladding down is because of the change in the rules.
Well, in my submission, the reason there is most certainly a purpose, my lords and my lady, and the purpose is that the reason why the cladding had to come down, it is for a reason which is not within the purview of the pleading.
Well, that's not quite the point I put to you. The purpose of the narrative is to say, this is the reason why it had to come down.
Even more than that, the purpose of the narrative is to say it doesn't really matter whether we made a mess of the dowels when we put this building together, or our employees did, or we left gaps in the insulation, which would have meant it was a fire hazard in any event. Because even if you prove all of those matters as being negligent and down to us, you didn't suffer the loss as a result of that negligence, because you had to bring down the building anyway, as a result of these changes in the regulations, or changes in attitude, shall we say, towards the regulations.
Well, my lady, there are probably elements of colour within that, Tracy, that my clients would object to, but as a broad précis, I accept it. And of course, it's right that in my defence, there are some of these workmanship allegations that we accept. There are admissions to some of those matters. That is absolutely right on the pleadings. But in my submission, 41.6, it certainly uses my defence. It's a response to my defence. I accept that much. But then it takes matters off into a direction which are novel matters, and they do not arise out of same or substantially the same facts and matters as are already in issue. And the reason why I lay emphasis on that point is because absent the amendment, in my submission, it is a fair analysis to consider what the trial would look like without the amendment. So absent 41.6, what would the trial look like? Well, there will be the 3 allegations of workmanship. Some of those allegations are not admitted, others are admitted. That there would then be a question as to whether those workmanship allegations have caused in law and in fact the loss contended for. That would be the whole of the inquiry. Of course, part of what I would be saying in that trial is that there were other reasons why the cladding had to come off. But beyond that, I would not go. And certainly I would not, unamended, be adducing expert evidence on the regulatory requirements, what could and should have been anticipated in relation to requirements in 2010, and so forth.
I'll tell you what I'm struggling with this analysis, and I see the way you put it completely. I understand it. Because it's always a question of fact and degree, to what extent there's something fresh that's coming in.
Yeah.
But if one takes the premise of the principles that Lord Justice Sales was talking about, Lord Justice Brooke was talking about in Goode and Martin, in principle, a defendant should be allowed, a claimant should be allowed to say, well, if what you allege in your defence is true, you're still negligent and you're still responsible to me. That's the basic principle. Your argument seems to me to assume that the claimant has effectively got his hands tied behind his back because he can't say anything more than what's already in the defence in terms of the facts that are pleaded. In other words, he can't go on and say because even if what you say to me in your defence is true, you're negligent, but you can't say you are negligent because, as a result of what you said in the defence, that amounted to a breach of duty for the following X reasons. And at the moment, I'm actually struggling with that as a concept.
Well, my lady, if I may deal with that briefly, hands behind back, 2 points on that. First of all, it has to be borne in mind that Martlet decided not to plead this.
Well, that's a jury point, with respect.
Very well. So that's my first point,
Yes.
and my jury point. And my
Moving
second
on.
point for the judges, my second point is that we don't think that, I wouldn't submit that it's a hands behind got you type point that the appellants
No,
are.
I didn't mean it in the got you sense. What I meant was it restrains somebody so that they wouldn't actually find themselves being able to explain why you were negligent if you couldn't say because.
Well, my lady, as I think, I will struggle to identify the passage. I think it may have been Lord Justice Nugie in Libyan Investment Authority in King who had said that, well, of course, that there is a constraint necessarily imposed by a statute of limitation.
Yes.
And so what one has to accept, and I believe that what Lord Justice Nugie said in Libyan Investment Authority was that, well, of course, Goode and Martin has to be placed within some sort of limits, because the concept of having a statute of limitation and prescription is that at some point you potentially lose your claims.
Yes, ultimately, you're entitled to say, well, you should bring all your claims in the first place, and that's the. I'm entitled to say there comes a time when there's a cut-off point.
Yes.
And that's the way that it operates, irrespective of the merits or otherwise of the claim.
Yes.
Limitation works. Sometimes it works well for one person, sometimes it works well for the other. But
Yes.
ultimately, limitation is limitation.
But my lady, in relation to your substantive point in terms of hands tied behind back, namely, as I have understood, my lady, that it is permissible, of course, for Goode and Martin, for the claimant to co-opt and rely upon what is set forth in the defence. But necessarily, I suppose, a defendant in a defence does not admit negligence.
No.
And so the point that my lady is making is that, well, can it be right that Goode and Martin allows a claimant to go only so far, but it precludes a claimant, or the claimant is precluded from adding on allegations of breach because they fall foul of same or substantially same facts and matters? Well, my lady, we would say on the authorities, and I'm going to go to a few passages which are review Goode and Martin. Goode and Martin was a rather unusual case, and all the facts that the plaintiff in Goode and Martin needed were, it seems, in the defence. And in my submission, whereas in this case, the claimant needs to go substantially beyond the defence to make out, particularise, as it has in 41.6, and establish at trial specific allegations of breach. The question is then whether those are substantially same or substantially same facts and matters. In other words, I would, I'm afraid, turn things round and say, why ought a defendant to be precluded from drawing a line and saying, well, I have pleaded these matters, but if the claimant now wishes to embark upon an entirely new case, the EPS case, surely the court, with limitation in mind and the limits on Goode and Martin in mind, the court is entitled to draw a line somewhere, because in one sense, the reductio ad absurdum of Milady's analysis with respect would be, well, once the defence allows a claimant to get their foot in the door, anything is possible.
Well, I think with respect, no. I think the answer is it's a question of what it boils down to is it's a question of fact and degree.
Yeah.
So, depending on the facts of the individual case, the launch pad is what's stated in the defence and what the facts are in the defence. The claimant must be entitled to at least allege that on the basis of those facts you were negligent because X, Y, Z. It's the moment that the XYZ starts turning into something which is outside of, or something completely new, which you couldn't have anticipated and wouldn't have been raised in the original pleadings, that you get the other side of the line. But each time it's going to be a matter of value judgment as to which side of the line it falls.
Yeah. Well, my lady,
You say it clearly falls on the wrong side of the line here because there's going to be some sort of great investigation into what was the state of knowledge of the art at the time when the building regulations were in place, when the cladding was put in.
Yes, I of course accept my lady's point that it has to be a qualitative question of fact and degree.
Yeah, well, I mean, I think we've got to that point, haven't we? Because, as my lady puts it, it's a question of fact and degree. And you said in answer to a question from my lord, you said, well, in relation to paragraph, the paragraph in the pleading, you said it was qualitatively a significant distance away from the defence.
And temporarily, I suppose.
Well, I understand that,
yes.
but I was using qualitatively. You made the points about
yes,
all the different ways you say it's different. But that I think is the issue for us on the central issue for us on your appeal.
On the appeal.
Yeah.
Perhaps I also.
Can I just say the passage I was interested in your citation, your reference to Lord Justice Nugie's comments in the Libyan case.
I have that from my
and
lord.
it's paragraph 52.
It is. Yes.
And then what he goes on to say in 53. Now,
Yes. 53 being, this does not put the claimants here in a position analogous to the claimants.
where she could not have anticipated.
Exactly.
Is that so? It's you say it's not enough to say it flows naturally from the defence. It's also got to. It's also got to be. Well, how would you put it? Substantial on the same claims as those on the existing claim. Same points, facts on the existing claim.
Well, no,
How would you
I'm not allowed to make that point because Goode and Martin doesn't let me.
No,
I-
I'm just wondering what do you want to say about what Lord Justice Nugie said?
Well, my lord, I was actually going to, having not remembered the passage, I was reminded of it by my learned junior. My point was paragraph 52.
Okay.
So that's obviously Bundle of Authorities 186. And the context for that is paragraph 50, provided rather by paragraph 51, Mr. Onslow's fifth argument. The essential point here was that the claimant was, the applicant for the amendment was seeking to contend that the amendment arose out of same or substantially the same facts as were an issue on parts of pleadings that had been struck out, essentially. And so the context is provided by paragraph 51, but then 52, Lord Justice Nugie says, I do not propose to consider the point at length. It is no doubt the case that any limitation defence can be said to impede the right of access of a claimant to the court. And so that was essentially the point I was alluding to in the course of argument. But then my lord invites me to make a submission on paragraph 53.
Well, I just wondered what you wanted, whether that.
Well,
anything.
I alluded to that point in an exchange with my Lord Justice Coulson at the start of my submissions, where the question arose as to, well, what's the relevance of the adjudication, and I lighted upon the fact that there were some authorities which perhaps suggested that part of the ratio or explanation for Goode and Martin it is the position that the plaintiff was in, the rather unfortunate position of having suffered concussion, having consulted somebody about what had happened. She most certainly wasn't in a position to anticipate the defendant's defence. Of course, that is rather different from our case, where the claimants specifically fought an adjudication including the EPS case, and lost, as it turns out, but then decided not to plead the EPS case. Now, that is, in a sense, for what it is worth.
Yeah, because we have to be slightly careful about overlaying part 17.4 with questions of anticipation, to use Lord Justice Nugie. I see that Lord Justice Nugie's judgment was a dissenting judgment.
Not on this point,
But,
or on
but on the in the result, I haven't looked at the. I have to confess, I've not looked at the detail. We'll look at the detail of that. But as you fairly say, you make that point for what it's worth.
I do.
But as I say, I would have a residual concern about saying that it was relevant to the operation of Part 17.4 as to anticipation and states of knowledge.
Yes, indeed. And
17.4 is complicated.
and my lord, it was a point I made. I touched on very lightly.
Yes, no. It's not a criticism.
No,
It's not a criticism. No, my lord is quite right to raise the point. But I think that that would be my Lord Justice Glidewell. That would be my impression of that.
Indeed, my lord. My lord, I propose to crack on.
Yes.
As I think the expression is. I'm on Goode and Martin and the cases that follow Goode and Martin, and in my submission are useful clarifications as to how far Goode and Martin can be taken. I've taken the court to passages in Goode and Martin already. I wanted to very briefly, please, go to MasterCard tab 8.
And this is, we've already seen Lord Justice Sales, haven't we?
Parts of Lord Justice Sales are cited in other decisions that we've been to.
So there's 42. Is it 41 and 42?
It is, my lord.
Yeah.
Absolutely.
So
41
summarised.
Bundle of Authorities 103 it is the essential facts of Goode and Martin. 42, the important feature of Goode and Martin is that in order to make out her newly formulated claim, the claimant did not need or propose to introduce any additional facts or matters beyond those which the defendant himself had raised in his pleaded defence. In effect, the claimant was allowed to say, and this is the passage that my lady has already identified, well, if you are going to defend yourself against my existing claim by reference to those facts you have now pleaded in your defence, I rely on those facts, if established at trial, to say you are liable to me. And my lady, my lords, my lady, we say that there have to be limits on quite how far the Goode and Martin principle can be taken, because if taken too far, all that a defence would need to provide for a claimant is a proverbial foot in the door, and then they're away with a series of breaches which may bear no relation to the original particulars of claim, but may be said to be arising in a broad sense out of the same or substantially same matters as are raised in the defence. But we come back, as it were, to questions of fact and degree. But my lords, my lady, we say it is of significance that paragraph 42 is in the terms that it is, and that in Goode and Martin, it would seem from the report of that case that the plaintiff in that case needed to rely on no further facts other than those averred in the defence. I propose very briefly to look at Acres and Samba on this point. And I know we've looked at Acres and Samba already. Forgive me, it's tab 9, but just on this point, it is of note in paragraph 41, so bundle page 119, paragraph 41, the case with the MasterCard, and then over the page there is quite extensive citation from MasterCard. And towards the bottom of the page, just before paragraph 42, that there is this citation pretty much in full of Lord Justice Sales in paragraph 42.
No, well, that was the one that my lady asked you about. So we've looked at that passage this morning.
Yes, indeed.
And then that's reflected in 49.
My lord, yes. And if we could then briefly go, and I'm conscious it's the decision of a Deputy High Court judge rather than a decision of this court, but tab 10, a decision of Mr. John Kimball QC, that's the decision in Hyde and Nigate. And I wanted to briefly invite the court to look at paragraph 30, Bundle of Authorities 138. The 4 points which I derived from MasterCard are as follows, and I'd invite the court to look at 30.2. Care needs to be taken with Goode and Martin. An important feature of that case is that in order make out her newly formulated claim, the claimant did not need to plead any, that seems to be underlined by the Deputy Judge, additional facts beyond those already in the defence. In my submission, the decisions after Goode and Martin are all speaking with one voice, namely that there have to be quite significant limits to the principle in Goode and Martin, namely that yes, same or substantially same facts and matters are already in issue, which may include the defence, but that is not carte blanche, and it doesn't open the door to any form of allegations by that route. That there must be some limit, and the limits are, in my submission, first of all, the rule, same or substantially the same facts, it provides its own limits, and secondly, as understood by the later authorities, Goode and Martin is a case where all the facts which the plaintiff needed to succeed on her claim were to be found in the defence. Now, my learned friend makes the point that, well, there is, on that view, a contradiction between that reading of Goode and Martin and the language of the rule, which is same or substantially same. And I accept that, but nonetheless, there have to be some limits. And the question, perhaps we come back to the essential question, matter of fact and degree, whether 41.6, as particularised in points 1 through 4, falls outside the rule. We say it most certainly does. My lords, my ladies, I wasn't proposing to dwell any more on the authorities. I was now briefly going to go to a few points that are made in the Respondent's skeleton argument, if I may. The Respondent's skeleton argument begins at, it's tab 10, core bundle, page 65. And if I could, I'm proposing to pick these points up really quite quickly. Paragraphs, this is the heading above paragraph 9 of the skeleton argument. Core bundle 67 is Martlet's original particulars of claim. Paragraph 10. For the avoidance of doubt, although Mulalley seeks to characterise these defects as workmanship defects, they're pleaded as design and or workmanship defects. And then over the page, final sentence of 10, the systemic nature of the defect is consistent with a failure of design as well as a failure of workmanship. And then a reference to what the TCC judge had found. This claim has always been in respect of both design and workmanship. The short point I wanted to make was those references to design have to be understood by reference to the analysis that I...
the contingent point.
Indeed. The contingent point and essentially the point that there are 3 workmanship breaches, but if and insofar as the defendant contends that the course taken in the construction was directed by drawing or a specification, then in those circumstances, but only in those circumstances, was there a breach of design. So in my submission, my learned friend's pointed his skeleton, and the point made by the learned judge, it is right, but only goes so far, and does not extend the ambit of the pleading, the original pleading, beyond the inquiry required for those 3 workmanship breaches. Paragraph 17. There's a discussion here, a description rather, paragraph 17 of the original reply, but bearing in mind the respondent's notice, I draw attention here to the language of additional alternative case in the second line. Martlet pleaded an alternative case, and then in the penultimate line was also a breach of contract. Those are, in my submission, indicia of a new claim, new cause of action. If I could then move on, paragraph 42, please. We say this is not right, paragraph 42. By advancing its EPS case, all Martlet is doing is adopting the same course as the claimant adopted in Goode and Martlet. Well, of course, that's the essential point on the appeal. We say, and I don't propose to repeat my submissions to this court, we say that they fall on the other side of the line. They are qualitatively different, and the court has my submission in relation to that. Paragraph 48, if I may. Mulalley is wrong to characterise Martlet's EPS case as wholly new. And then there are reasons. 48.1, as explained in paragraphs 10, 11 and 30 above, the existing particulars of claim were not limited to issues of workmanship and were not focused on a discrete set of workmanship defects. Mulalley's design was always in issue. It's the same point as I've made already, but in my submission, yes, that is right, but it depends what one means about design always being an issue. It was an issue within the four corners of the three pleaded workmanship defects or three pleaded allegations of breach, but no more. 48.2, even if Mulalley's design was not always an issue, that would be no answer. And then there is a reference to the judgment of Lord Justice Sachs in Brickfield Properties and Newton, the well-known 1971 case. I don't propose to read that passage, but essentially the point that my learned friend relies on is that there is, in this case, as there was in Brickfield, a mix of allegations of design, workmanship, and therefore they're all within the same compass. In my submission, that analysis is too general and does not survive in light of the analysis of this court in decisions such as Burse and Ballinger. At 48.3, as explained in paragraphs 15 to 18 above, Martlet's EPS case arises out of Mulalley's causation defence. Well, yes, but no. It arises in the sense that it is a response to my causation defence. That is obvious. But there is no, it does not flow necessarily from it at all. The amendment embarks upon a series of allegations of breach, which are, and I'm now at risk of repeating myself, they are not within the particulars as originally pleaded, and they are not within the defence. So I wanted to just make those points in relation to my learned friend's skeleton, but perhaps I ought to also just touch on paragraph 49 of the skeleton. This is Martlet's point that the allegations in the particulars of claim and the EPS case are all part of, they relate to one system. In my submission, that is not an available analysis. It's not the right analysis at all events, in light of what Lord Justice Tomlinson and this court said in Burse and Co-op and Burse. Briefly, fourth, I'll briefly address, my lords and my lady, the additional grounds.
Sorry, just to think that point through, what you mean, you accept that they are all part of the same system, but that didn't help the amending party in Burse, because it didn't help the amending party to say it's all part of the flaw? Is that the point?
Yes, my lord. Of course it's right. In this case, the EPS insulation and the cladding, it might be regarded from a technology construction point of view as all part of a single integrated system. That may well be right. And equally,
So just so that we understand, is the EPS sandwich in the middle of aluminium strips? The cladding, very simply, is it? It's a composite system.
Yeah.
And is it built on site or is it pre-built?
Prefabricated.
Prefabricated. Okay. So you accept that the EPS and the fire barriers, it's all part of the same system.
Well,
but you say, so what? It was all part of the same flooring in Perth.
yes. Well, forgive me. It's apparently it's built on site.
Okay.
The components are brought to site and they're constructed on site.
Fine.
The
But
EPS is a form of insulation.
Yeah.
And of course, then there is cladding as well.
Yeah.
And in one broad sense, it might be said, well, it's all part of one system. It was all brought to site, designed and constructed by the designer build contractor. I accept all of that. But what I would say is, well, that is also true. That was also true of the contractor in Burse in Co-op and Burse, because the contractor constructed the whole floor, and it was responsible. So my clients had pleaded that for the lack of inclusion of metal in the reinforcement. But what Lord Justice Tomlinson set forth in the judgment of the court is that that was not enough to ground a submission that the amendments arose out of the same or substantially the same facts and matters as the original plea.
So does it come down to this, that if you've got a system or a state of affairs on the ground, and the claimant says, well, the system was defective in the following two respects, and that made it unsafe for various reasons, you can't then add a third reason why the system's unsafe, if to do so involves raising completely new factual allegations which need to be investigated.
My lord, my lady, forgive me. Essentially, yes.
Yeah.
Yes, and that is essentially the fact of person car.
Yeah.
That there has to be a line drawn, and yes, it may be all one building, and it may be all one system in some connected technological sense, but one has to analyse the matter, as Lord Justice Tomlinson explained, both in Co-op and also in Ballinger, somewhat more closely. And therein lies, as it were, the qualitative argument about, well, where does one draw the line?
Yeah.
Paragraph 58, just to finish, forgive me, I ought to have made this point. Paragraph 58 of my learned friend's skeleton argument, and perhaps I've been as guilty of this as my learned friend is. He prays in aid the adjudication, and he says that paragraph 58, moreover, is recorded by paragraphs 49 and 50, the judgment, the court already has before it evidence of what would be litigated between the parties in any event if the unamended claim were to be pursued. That is because there has already been an adjudication between the parties. Well, that in my submission can't assist the analysis. Essentially two reasons. First of all, beginning an adjudication does not do anything as regards the statute of limitation. And secondly, all of the authorities, although they approach various issues with a degree of nuance and difference, they all speak with one voice in my submission, which is that this question under 17.4.2 has to be analysed by reference to the pleading.
Well, that's why I said earlier, again, questions of actual knowledge or subjective knowledge, objective knowledge, it can't arise.
No, well, I accept the characterisation of that point as something for the jury. I accept that, and I am not contending that it needs to be an over-elaboration on the test which is set out in the rules.
No.
The additional ground, that was my fourth area for submissions, and I can take this very swiftly, perhaps best by reference to the amendment, the underlined amendment itself, Core Bundle 158. In terms of the, not just indicia, but essential requirements for a claim or cause of action, reminding oneself as to those. First of all, obligation. Whilst it is right that the first 10 or so lines of the amendment 41.6 repeat various components in the building contract, they are here being used for a different purpose, because they're being used to support allegations that the selection and use of the EPS as insulation in design and construction of the cladding works was a breach of the contract. So they're being repurposed. So in that sense, there are new pleadings of obligation. But even if I'm wrong about that, when one gets into the detail of this amended plea, at the bottom of the page, this meant that. And then we have 41.6.1, and over the page, I don't propose to go back over that. These are breaches of obligations which are new. They are introduced into the pleading for a new purpose. And in a sense, by making that submissions, I've leapfrogged over to breach as well.
Yeah.
These are new breaches. So they're new obligations or repurposed obligations. They are new breaches. And also the loss, although as I mentioned before, on a trivial basis, the loss is the same because it's the whole cost of replacement and fire watch, waking watch, and so forth. As a matter of analysis, the EPS case is prayed in aid by the claimants as founding an entirely new route to the damages. Because it's plain on the face of the pleadings, the amended pleadings, that if my learned friend, for example, fails on liability in relation to the 3 original pleaded breaches, he moves to his EPS case.
Well, it doesn't matter, because on your case, it doesn't matter whether he fails or he wins, because even if he makes out the negligence on his original case, you say you've got a causation argument to it.
Yes, the point, my lady, I'm on is in respect to the additional ground, namely the contention by respondent's notice that this amendment isn't even a new claim or cause of action.
I appreciate that. I mean, you're saying, I was agreeing with you, that the what was never there was an allegation that you had breached your design obligations in respect of the cladding.
Yes.
There were allegations in relation to the workmanship, in relation to the gaps and the dowels and so on, and there was a contingent claim that was a design defect in case, in anticipation, you were going to say, well, we follow the drawings. Exactly. But what there wasn't, there now is a claim based upon the choice of the cladding and putting that in.
Yes, yes. And so it is for the reasons I just outlined very briefly and in my supplemental skeleton that we say that the respondent's notice is that ought to be rejected, that alternative basis on which the judge's orders should be upheld, that should be rejected. But in summary, my lords, my lady, we invite the court to allow the appeal and reject the case found in the respondent's notice, the additional ground.
The causation argument is quite interesting, isn't it? It's a pity that we're not deciding that, because if Mr. Selby is successful on what you characterise as the workmanship defect, and assume you're right that it all changed as a result of the advice note and so on. Does that give rise to a causation defence? Isn't that res inter alios acta, as they didn't say at my Red Brick University?
I suppose it will be for the judge.
Well, I understand that. I'm just exploring my disappointment that this isn't an issue that we can deal with. Anyway,
well, perhaps not yet, man.
Anyway, we can't. All right. I don't have any questions, but hang on a moment. No, none of us have any questions. Thank you very much, Mr. Hughes. Yes, thank you. Mr. Selby.
My lord, can I just take my wig off so I can take off my face mask?
Yes.
Most unusual request, perhaps.
And I apologise to everybody in court who's not talking. You have to wear masks. We do appreciate the nuisance value of that, but in the current circumstances, it's inevitable. So thank you all very much. Yes, Mr. Sully.
Thank you, my lord. If we take the 4 questions posed in Hyde and Nigate as the starting point, no issue arises in relation to question 1. It's accepted that the opposed amendments are outside the applicable limitation period.
Yeah.
There is also no challenge to the judge's ruling on question 4. There is no issue on this appeal about whether or not the amendments should be allowed as a matter of discretion.
Yeah.
The only issues on this appeal relate to what might be called questions 2 and 3.
And 2 is it a new claim, and 3 is, if it is a new claim, does it arise out of the same or substantially the same facts and matters?
Absolutely, my lord. Yeah. So on that basis, I'm going to make my submissions under the following 3 headings. The first is the parties pleaded cases. The second is question 2, is this a new claim? And the third is question 3, whether Martlet's EPS case arises out of the same or substantially the same facts. When I pick up question 3, obviously I will pick up Mulalley's grounds 1 to 4 as best I can. So if we start with the parties pleaded cases, to some extent I'm going to go over some of the territory I know that Mr. Hughes has taken you to, and I know that you have read already. So I will canter when I can and slow down if either the court tells me to or where I think it's appropriate to. But the starting point, of course, is the claim form at tab 14 of the core bundle. And the one bit that Mr. Hughes didn't read out to you starts in the 4th line. After the words in parenthesis, the defendant carried out its design and or construction work on the towers defectively. Now I accept that you don't get much from the claim form, but it is worth remembering that the claim form does in terms formulate Martlet's case as a claim for defective design as well as a claim for defective workmanship. Then if we move on to the particulars of claim, at the next tab, tab 15, I am going to start with duty rather than breach. First is to make the obvious point, which is as you'll go through the section on breach, the particulars of claim plead no additional duties by way of amendment. But I also want to make some points on the pleaded obligations, if I may. So the starting point is paragraph 16 of the particulars, which is at bundle page 148. And that's where we plead clause 6.1.1 of the building contract. And you see it sets out, starts with clause 6.1.1.1, and that effectively says that clause 6.1.1.2 applies, and then if you turn over the page, you see the obligation 6.1.1.2, the contractor shall comply with any act of Parliament, any instrument, rule or order made on the act of Parliament, or any regulation or bylaw of any local authority or of any statutory undertaker. That is the obligation to comply with the building regulation. As Mr. Hughes conceded, the obligation to comply with statutory requirements.
Yep.
And we see similar obligations at paragraphs 21 and 22. So if you turn over the page to bundle 150, there's clause GI 010. Nothing contained in the employer's requirements is intended to override any statutory requirements or the requirements of fire officers and so on. The design and build contractor is required to ensure that the ultimate design satisfies such other requirements, notwithstanding anything contained within this document. And then underneath at GDI 001, the works are to be designed and constructed in accordance and compliance with all relevant and related statutory requirements, codes of practice, and so on. we say those obligations are significant because they mean that issues about whether or not Mulalley exercised reasonable care and skill in its design are irrelevant. Either the system complied with the building regulations or it did not. Whether Mulalley exercised reasonable care and skill in its design or not makes no difference. And that sets the
strict liability.
Strict liability. And so Mulalley's complaint about the additional factual investigation required in respect of the design claim simply does not arise on much of the design case. We do also plead an obligation of reasonable skill and care, so it would arise in relation to that. But that's a secondary point, because my primary point is you either complied with the regulations or you didn't.
No.
Just carrying on through the obligations, just because they are pleaded in the section on breach. At the bottom of the page, paragraph 25, it is GDI 008 of the employer's requirements. That required Mulalley to use the most appropriate grade or type of material or proprietary product. And then over the page at 31 is where we get into the contractors' proposals, and we see at section 2D of the proposals at paragraph 31 where it refers to the use of the stove system and expressly describes it as a very high quality system specially designed for high-rise usage. Also refers to 10-year warranty. And then over the page at paragraph 32, section 7 of the contractors' proposals, where it specifically describes the benefits of the system as being Class O fire rating and lightweight materials make this system suitable for tall constructions. So again, these warranty claims are similar to the point about building regulations. Either you complied with these warranties, it's either suitable for tall constructions or it's not. Whether you exercise reasonable skill and care or not.
That, of course, would be a matter of evaluation, wouldn't it?
Yes.
Because it's not, in some ways it's a representation of fact, but suitability is a mixed question of fact and opinion.
Yes.
Yeah.
And then we see the statute.
So it does involve an inquiry. That aspect, unlike the
course.
strict liability,
Of
unlike
course.
the regulations.
Whenever you're looking at a breach, there's always some form of inquiry, unless it was a pure, if I can call it a pure warranty that black is white says.
Yes.
Which we don't always get. We'll rarely see, certainly in the context of construction contracts. So then we come to the statutory requirements, which also builds on the point my Lord has just made at paragraph 35. At 35.1, we set out the relevant requirements contained at Schedule 1 to the building regulations, and over the page at 35.2 you see requirement B34 and requirement B41. B34 is relating to the inhibition of the unseen spread of fire and smoke within concealed spaces in the building structure and fabric, and B41 relating to the spread of fire over the external wall.
Can I just stop you there?
Yes.
These are the building regulations 2000.
Yes.
It's your case that those are the relevant regulations at the time of the contract.
Yes.
And so the yardstick by which the works are to be adjudged for building regulation purposes, the building regulations 2000.
Yes.
And what are we up to now? What are the?
It's the building regulations 2010.
Yeah.
And
Have I seen some reference to 2017?
2017 is the date of Grenfell.
Yes, but
So that's why
the building regulations haven't been amended post Grenfell. There've been advice notes, what have you.
I think what I can say is not amended in material respect for present purposes.
Okay, fine.
What's changed is you have approved documents, my lord might well remember, that are guidance as to what will amount to compliance or not, deemed compliance in relation to the regulations. There was an approved document in 2002, and then there was a later approved document in 2006.
Right.
And I think there might well be a new one in play.
Okay. But anyway, the building regulations with which we are concerned and which you have pleaded in paragraph 35
Yes.
are the building regulations 2000.
2000, yeah. Now, if I could just make a point on that, picking up what my Lord Justice Baker said, these are functional requirements. And so if you take B41 as an example, it's the external walls of the building shall adequately resist the spread of fire over the walls and from one building to another. So of course you've got to make a value judgment as to whether or not the external walls adequately resist the spread of fire. That's what's required. So that's the first point. But then of course the second point is it's looking at the external wall as a whole. It's not a specific requirement about, say, the manner of installing fire barriers or EPS insulation. And so in assessing compliance with the building regulations, on my originally pleaded case, the court will be assessing the performance of the external wall as a whole, not simply the individual components within that wall. So then we come to breach at paragraph 41. And I know your lordships have looked at this quite carefully already, but if I can just make my points as quick as I can. In terms of what was originally pleaded, the first set of breaches in the first 8 lines of paragraph 41 were pleaded as design breaches. And the second set, starting about line 8 of paragraph 41, were pleaded as workmanship breaches. And that's all consistent with the language of the claim form. And what you...
But there are no particulars given of a design defect. That's the problem. I mean, if you just looked at 41 on its own, I quite agree with you.
Yes.
It said, well, you were in breach of various clauses in terms of the design.
Yeah.
And you were in breach in relation to the... and/or you were in breach in relation to the workmanship of the cladding works, fine. Then you look at the particulars, and they're all particulars of workmanship defects.
Well, my lady, that's where I disagree with the premise to your question and what my learned friend Mr. Hughes has said to you.
He concentrated on the verbs.
He concentrated on the words fixed,
fixed,
or
left, fixed.
And of course, that sounds like someone's gone there and put it on. But in my submission, these are as much particulars of a design failing as a workmanship failing, because what they address is the outcome. How this system was placed on the walls, rather than the process, which you might more commonly see, where the client has the design in place, has the design before them, and they can say, look what you said in this drawing, you said X when you should have said Y. Now we don't have that, we still don't have the relevant drawing. So we have pleaded our case on design and workmanship by reference to the outcome.
There were an insufficient number of dowels.
I know my lord focused on the dowels, but
well, no, I don't. I'm just.
That's one of them. But
the dot and dab method of adhesion
yes,
was used
yes,
rather than a continuous band.
yeah.
So your point is, well, that could be design, could be workmanship. They'll know, we don't.
Absolutely, my lord.
Because there could have been a drawing which said use the dot and dab and here's how you do it.
Yeah.
Or it could have been done on site and the clerk of works diary says we're using the dot and dab, don't tell anybody.
Yes.
I mean that's obviously
Well, just because said we're
the
using
old
the
days
dot and dab.
the old days of a clerk and works diary that had a proper record of what had been built. But that's the short point. Could be design, could be workmanship. You say
Yes.
You don't know,
I don't know.
or you didn't know at the time of putting together the pleading.
No. And just to put my client's state of knowledge in context, we acquired this development after these refurbishment works had been done, so we weren't party to the original building contract.
Yeah. Understand.
You saw the response to the request for further information already. I don't need to go back to that, but that is essentially the point that we've just picked up on. The other point, of course, is that the defects uncovered by Martlet were universal, or dare I say it, systemic,
Yes.
from top to bottom of every elevation of all 4 towers.
All of these
The same defects.
complaints were throughout.
Yes. So where defects are universal,
Points towards design.
they could just as easily arise out of errors in design as well.
And
as
these are towers, so these are quite a lot of
It's about
dowels
quite a lot of
involved.
quite a lot of fire barriers in particular, my lord.
Yes.
At every floor level.
So more than one workman.
Well, no doubt more than one clerk of work
Yeah.
or
And it's
supervisor
in all the towers.
on all 4. Well, there were 5 tires. I can only run.
Yeah, or
claim
the
for
four we're thinking about.
Yes,
Throughout.
throughout.
So do you say that's more consistent with design than workmanship?
I think that's for another day, my lord.
Okay. Yes, okay.
I say for present purposes, just as consistent with design.
That's as far as you need to go.
Yes. And that's why the pleading's put in the way that it's put. And that's why, just for the sake of the record, we agree with the judge when he concluded that the originally pleaded defects were pleaded as breaches of Mulalley's design and workmanship obligations. And that's paragraphs 7, 9 and 51.1 of the judgment. Now, sorry, my lord, you're looking at the time.
No, I am looking at the time to see where we are.
Yeah, understandably. I will.
It's 8 minutes to 1, in case anybody wondered.
My lord, you can either gong me off or I'll tell you.
No, you carry on.
But if we go now back to paragraph 41 of the particulars, we can start to pick up the amendments.
Yeah.
So back at bundle page 155 of tab 15. First, we see that Martlet's added selection of goods and materials to design in line 1. In my submission, that adds nothing to the fundamental nature of the allegation. Selection of goods and materials is just a different way of describing design.
Mm-hmm.
Second, we see that Martlet have added reference to 3 additional clauses in respect of its design case. GDI 008 and the sections of the Contractors Proposals. They are the clauses that contain the warranties that the system was suitable for all constructions and the obligation to use materials and products of the most appropriate grade or type. But you'll also see that 2 out of 3 of those clauses were already said to have been breached. In the workmanship section,
They were pleaded already. They weren't. They weren't included. The paragraphs weren't added because they were already there.
the terms were pleaded, but
Yes,
also
I mean.
breach of those terms is already
Yeah.
pleaded in the workmanship
Section.
half of paragraph 41. You see GDI 008, 2 lines from the bottom of page 155. And if you turn over the page, at the top you see section 7 of the Contractors Proposals. Also, it was already alleged in paragraph 41 that the design did not comply with the building regulations. We see that because you see alleged breaches from line 4 of a breach of clause 6.1.1.2, and then you also see the next line, paragraph GI 010 of the Employer's Requirements, and also GDI 001. I feel like I'm in a James Bond movie.
And those are the requirements that back up paragraph 35. You say the statutory requirements referred to in clause 6.1 of the conditions of contract and paragraphs GI 010 and 001 of the employer's requirements included.
Yes.
And then there are the two building regulations you took us to before.
So just to be precise, and if I'm being pernickety, forgive me, it's building regulations requirements rather than building regulations. It's building regulation 4 that says you comply with the requirements. The requirements are in Schedule 1. B34 and B41 are in Schedule 1.
Okay, so it's the requirements in Schedule 1 of the building regulations.
Yeah.
Okay, got that.
So then if we look at the particulars,
The building regulations are only pleaded, or the breach of the building regulations are only expressly pleaded under the workmanship section. Is that right?
no, both design and
Is it?
partnership.
So you go 1, 2, 3, 4 lines down. You've got clause 6.1.1.2, which is the statutory requirement.
Yes.
Okay.
But it's the next line, the GI 010.
Yes.
Because those are the ones you've set up
Yes.
at paragraph 35 of the pleading at 152.
And GDI 001.
Yeah, and GDI 001.
Okay, I've got it. Building regulation 7, which you plead at the end, is only relating to workmanship, as you said in 35.4.
Yes.
Okay, carry on, Mr. Selby.
Yep. Okay.
Ignore my
I see.
witterings.
So my lord is right. Regulation 7, whatever that says, and you must have set that up somewhere,
35.4.
is in the workmanship.
Yes. So regulation 7.
Workmanlike manner.
Yes.
As we carried out workmanlike.
So that would be in workmanlike manner. Sorry, that would be in the workmanship point because it's workmanlike manner.
Yeah.
Got it.
Yeah.
Thank you.
Right. Particulars. Paragraph 41.1. So you see the fire barrier defects are alleged at 41.1 to 41.3. The particular one, and it is worth explaining to some extent, is 41.1. The fact that the fire barriers are fixed using these dabs of adhesive rather than a continuous band of adhesive, because what that means is that there's gaps behind the fire barriers for fire or smoke to spread through the fire barriers. They don't do the job they're supposed to do. And so at 41.2 you see more gaps. These are vertical gaps where one fire barrier abuts another. There's a gap between the two barriers. So again, passage for spread. And then the dowels relates to how well fixed the fire barriers are held in position. And of course, if they're not the right number of dowels or the right depth of dowels, the barriers won't be held in place as effectively as they should otherwise be. But then you see this at 41.4, still in my original pleading. As a result of the matters aforesaid, the external walls do not comply with requirements B34 or B41 of the building regulations. So on the original claim, there is a live issue about whether the external walls comply with the building regulations or the building regulations requirements.
But for those reasons,
But
there
for
isn't
those
there isn't a live issue as to whether they were non-compliant for other reasons.
Yeah. Then you see at 41.5 the originally pleaded case in relation to the EPS installation.
fixing.
and the way it's fixed the wall. So again, it was dabs of adhesive with no, I can't believe I'm using the word sausage in the cause of appeal, but no sausage or ribbon of adhesive around the perimeter of the insulation boards. So again, what you've got is a route of air all the way up the back of the insulation, and again carrying through the fire barriers all the way up each elevation. And then there's also the point about the dowels holding the insulation in place. So not only is there a claim in the original pleading about the fire barriers, there's also a claim in the original pleading about the EPS insulation. And just pausing there, can I remind you of 3 points, and then that might be a good time to stop for lunch. First, what is installed is a Stowe external walling system, which comprises the insulation, the fire breaks, and the render, and certain other components that are immaterial for present purposes. So what went on the walls at Gosport Towers is not some sort of bespoke design solution. It's a system that Stowe sells to the wider market and has done so since 1963. I don't need to take you to it now, but if I can just give you a reference for your note, there's some Stowe documentation in the Contractors Proposals. That's Core Bundle, tab 18, at pages 301 and 304, where you'll see it's marketed as a system. Second point is that the court needs to remember the interrelationship between the EPS and the fire barriers. Now, I don't know if, my lords, you remember the photograph in my skeleton argument. It does go back to one of the...
Well, if we're going to come to you want us to show us a detailed bit of the construction, that's fine, but we will do that at 2. So this is the relationship between the EPS and the fire barriers?
Yes.
Within the Stowe system?
Yes.
Yeah, fine. Okay, well, you can show us that at 2 o'clock. Good. Thank you very much. 2 o'clock.
Before